Hello, viewers. Welcome to another lesson. In today's lesson, we shall be looking at bail application in Sierra Leone. And this lesson has four objectives. The first is for you to understand the meaning of bail. Second is for you to know the types of bail. Thirdly, we want you to know the authorities that grant bail. And lastly, for you to know when and when not to grant bail. Now, bail is defined as cash or bond given to the court by a prisoner to secure conditional release from custody, and the prisoner promises to return for judicial proceedings at a later time. A failure to return triggers the bond obligation and allows the court to keep any money given as security. So it is either cash, that is money given, or agreement, that is bond, enter into on promise to attend court proceedings when called upon, which makes it conditional. And there are two types of bail. The first is self recognizance bail, and the second is non self recognizance bail. The first happens when the court dispenses with sureties. If, in its opinion, its so dispensing will not tend to defeat the ends of justice. And this is authorized under Section 79, 4, and 7 of the Criminal Procedure Act of 1965, meaning there is no requirement to provide sureties or guarantors to ensure your attendance when later called upon to answer to the charges brought before the court. Secondly, we have non self recognizance sureties, bail. And this type of bail is granted when the prisoner or accused person provides sureties or guarantors who will stand or ensure the appearance of the accused person when called upon later to answer to the charges before the court. And this is authorized under Section 79(6) of the Criminal Procedure Act of 1965. Now, to who grants bail? Three authorities grant bail within the Sierra Leone jurisdiction. The first is the judge, and the judge under the Criminal Procedure Act means a judge of the Supreme Court by then, but now the High Court of Sierra Leone. And a judge is the chief administrator who hears and determines cases brought before the court. Secondly, we have the court. And the court under the Criminal Procedure Act of 1965 is defined as any court of criminal jurisdiction established by law in Sierra Leone other than in local courts in the provinces administered under the Local Courts Act of 2011, meaning that it should be a court of criminal and not civil jurisdiction. And secondly, it should be a court, not a local court, meaning in the local court, nothing like bail exists. Now, thirdly, the police can also grant bail, and they can grant bail with or without a warrant under Section 80, subsection 1 of the Criminal Procedure Act. Secondly, they can also grant bail for all offenses save for murder and treason under Section 80, subsection 1, paragraph A of the same Act. Now, when to and when not to grant bail? In the first place, offenses of murder or treason do not attract the granting of bail except by a judge under Section 79, subsection 1. So, this is also an instance where bail cannot be granted. Secondly, other felonious offenses such as rape, wounding with intent can also attract bail by the court if it thinks fit to do so. So, in the second place, bail can be granted by the court, and the court has been defined earlier. Thirdly, other offenses other than felony can attract bail as the court pleases. Now, felonious offenses are those offenses that can attract a sentence of imprisonment or death generally, and that non-felonious offenses are those that can attract fine or imprisonment. So, for instance, street liability offenses, road traffic or offenses, for instance. And These offenses, which are non-felonious offenses, are captured under Section 79, subsection 3 of the Criminal Procedure Act of 1965. Thank you for listening. Thank you for watching. Please like, hit the notification bell, share, and drop your comment. I'll be right back next time.